Well, good afternoon, everyone. Thanks for coming on this lunch hour. We're going over RECLA today. So kind of the flow of the presentation will be, we'll talk about what it really is. We'll talk about how a homeowner can sue you and for what, and we're going to wrap it up with, ways to avoid and ways to resolve. So as we go through here today, um, just keep in mind that your options in these situations are almost limitless. You have a lot of different ways and you can be very creative in solving these issues. And so I'll tell you from experience, I have handled several of these cases recently from the homeowner side. So certain things that I'm going to bring up is I've seen how a contractor could have avoided a lawsuit or a situation because they could have just done very simple things for my clients instead of having now a lawsuit that's been dragging on for over 2 years in a couple of the situations. So if we start with defining RCLA, let's kind of start there. We'll start with the scope of what it is. What it stands for is the Residential Construction Liability Act. And it works to do a couple of things. One is to limit the homeowner's rights against you. But what it also does is it provides a scheme where the homeowner and the contractor get to go back and forth. It's kind of a forced settlement discussion that has to occur before a lawsuit can even be filed, or if it gets filed early before this back and forth has occurred, it allows the lawsuit to be paused as you kind of do a back and forth. And if the steps aren't followed by the homeowner, it can really limit what the homeowner damages can be, the amount of money they can collect from you, and things like that. It's found in our Texas property code. And if we go through how does it work, what we'll see is that it applies to construction defect claims, single family, duplex, triplex, anything and above, right? If it's something that an individual can live in, it applies. So it's more than homesteads, it's more than, just where someone actively lives. It can be vacation homes. It can be that you're going in and you're renovating someone's Airbnb or their rental property or whatever it may be. It's just residential, period. There's no exemptions or exceptions for homesteads. If you guys have ever done anything with liens, you know that there's all these extra steps that have to happen with homestead exemptions and things like that. None of that is going to come into play here. It's a residence where someone lives, and you have done work, whether you have built the home, whether you're going in and renovating the home, whether you're going in and repairing the home, it's going to apply. And it's going to apply to you as the contractor if you are having a direct contract with the owner. So for some of you guys, you may very well go into a project. Let's say you do a lot of plumbing work in, with the pipe burst and the freeze or any sort of, hurricane flooding or anything that may come up. And you go to a project or a homeowner and they contract directly with you, and you're supposed to be doing repairs or maybe putting in a new bathroom or whatever it may be, this is going to apply to you. It is the way it's not going to apply to you is if you are not the one entering into the contract with the owner. So let's say someone wants a new room added on to their home, and that's going to come with a bathroom suite. Basically, let's say they're doing like a mother-in-law suite, adding it on to their house, and they hire a general contractor to kind of guide the process, draw up plans, whatever it may be. That general contractor then hires you as the plumber or the electrician or the drywall guy. At that point, RCLA is not going to come into play to you. It may, happen where the homeowner gets mad at the general contractor, that then flows back to you. But that falls into a typical breach of contract situation, not this Residential Construction Liability Act framework. And so as I say, RCLA going forward, that's just the shorthand for this statute that pops up in the property code and kind of the procedure that has to happen. So as we move forward here, let's talk about what the process is. It's hard to kind of nail down this timeline because sometimes, once the homeowner acts or you act as the contractor, then that triggers the next timeline. And so first step is homeowner realizes something's wrong, right? To officially kick off the RCLA process, they have to send you a letter listing out everything that they think is defective in the home. I will say from practice, when I have a homeowner client, we list it out. We attach to that letter any inspection reports that have been done, any bids from contractors showing the scope of work that is recommended to be done, anything to be as full and complete as we can. But that doesn't mean that's what you're going to get every time. So, there is some legal technicalities you can try to get into and be like, okay, well, they just sent me an email. So technically they didn't, send it certified mail like they were supposed to, or they didn't do, certain requirements under the act. And typically what the law is going to do is it's going to kind of give the homeowner a break if they aren't following the letter to the law, because they're homeowners. They don't know, they don't go research Chapter 27 of the Texas Property Code like I do when a homeowner hires me. So just be aware that any sort of written correspondence that you're getting from your homeowner, it could really kick off this process. And so then what happens is they send it to you. From the date that you receive it, you have 35 days to either request additional documentation. And what you are allowed to request is built right into the Texas Property Code. You can ask them to give you any consulting reports, any engineer inspections, any other bids, anything that they may have that's a document that didn't come with their letter. So kind of my first recommendation here is, right, you get a letter, you immediately turn around and ask for the documents. Because they don't necessarily have to give them to you, but you are entitled to them. Also within that 35 days, you need to request and inspect the property. You need to go in and you need to do as thorough of an inspection as possible. You have 35 days to get that done. Now, that can be a short amount of time. It can be hard to schedule. So the law does provide that with a written agreement between the parties, between yourself and the homeowner, you can agree to extend any of these deadlines or any of these timeframes in writing, whether it's email or text message or anything like that. I prefer email, makes it a little easier, but you are entitled to that. Just keep in mind though, that you need to make sure you're extending both this 35 deadline and then this next one we're talking about as 45 days. So you must provide a settlement offer to the homeowner for the listed defects within 45 days of the date you received the letter. So to talk about how this gets a little tricky is, so let's say you get a letter on August 1st. Let's just make it really easy. That means you have through kind of that first week of September to, I guess it would technically be like September 4th, to request additional documents, request an inspection, and to inspect the home. And let's say you do that by August 15th, because you have a really responsive homeowner. Well, now you have up to that 45 days from the date you received your letter to do your settlement offer. So it gives you a lot more time to look over documents, to put together something formal, to really think about it. Let's say you inspected on the 15th of August. Well, now you have until August 14th to put together some sort of offer. That's almost 30 days that you have plenty of time. But you have the other scenario. Let's say you weren't able to inspect until day 35. Well, now you only have 10 days to put something together. So you just really need to be aware of those deadlines of when you need to get that offer over to the homeowner. So now you've done step one. You've inspected and you've sent that offer over to the homeowner. Everyone's good and happy. You're within your timeframes. Now the ball's in the homeowner's court. From the date the homeowner receives your offer, they then have 25 days to either accept it or reject it by writing back to you and detailing why the offer is unreasonable. So for example, let's say, and we'll get more into reasonableness later, but let's say that they were having a bunch of issues in their bathroom. You've remodeled their bathroom and the tub is leaking and the faucet's not working, the cabinets aren't shutting properly, and you send an offer back and you're like, okay, I'll repaint the cabinets. Anyone can tell that that's not reasonable, right? There were 3 or 4 other things you just even failed to address in your offer. And so what the homeowner is going to do is they're going to look at it, they're going to write back to you, and they're going to say, hey, this is unreasonable because you didn't even address the bathtub that was leaking. You didn't address fixing the cabinets that don't close. You didn't address the poor sink problems. And they're going to come back to you with a list. And thankfully, them coming back and saying your offer is unreasonable doesn't end the process, because what you then are allowed to do is come back with a settlement or a supplemental settlement offer. Now, if the homeowner just ignores you for those 25 days and those 25 days run without any sort of acceptance or even a letter rejecting it, the law deems that your offer has been rejected after those 25 days. And you are still entitled to then do a supplemental offer within those next 10 days. So as we move along here in the presentation, I think we'll talk about next is a supplemental offer. Okay, so this is kind of what we had just talked about here. You know, you receive their response, you have those 10 days. You can either address their concerns in their letter, or you can maybe up their offer. So let's say, for example, you don't want to deal with them anymore. They're complaining about the bathroom remodel you did, just to stick with the same example, and they've got some bids that it's going to cost $10,000 for them to get it fixed or fix your defective work or whatever it may be. And you say, okay, well, I originally told them that I would give them $8,000, but you know what? I don't have time to deal with this. I'll just give them that full 10,000. Hopefully they accept it, you know, and we're good and done and dusted and everyone walks away. But if it doesn't settle at that point, it's very likely you're going to be sued because you did the back and forth. It didn't work out. You now have a lawsuit on your hands, potentially, right? They have to go hire a lawyer. Maybe they've had a lawyer the whole time with this back and forth, but regardless, they file a lawsuit on you. If the homeowner is asking for more than $7,500, there is the court, or the law, excuse me, the law says that if you ask for mediation, the court must order it. Now, keep in mind, there are some timelines there. You have to ask for mediation. I believe it's 60 days after the lawsuit has been filed. You can ask to be ordered to mediation and the court must make you go. This kind of gives you that second bite at an apple. For those of you that have not been to mediation before, just a quick overview of what it is it's almost like a second round of informal settlement discussions. You have a third party there that helps facilitate, right? So instead of it just being you or your attorney sending letters or communications to the homeowner and the homeowner's attorney, what you now have is an intermediary that goes between the two. And this often becomes a helpful and effective way to settle cases, because what this third party neutral does is they may come into your room. Typically you stay separate. These days we're separate in virtual rooms, sometimes with Zoom mediations, but they come in and they say, hey, you know, here's some weaknesses in your case, or hey, you really need to understand the realities of how expensive these cases can be. It may be worth putting a little more on the table, even though it's a tough pill to swallow. Then maybe they go into the homeowner and they may say, hey, look, you're a homeowner going up against a company that has money at its disposal to fight a lawsuit. You know, you need to know your risks. You need to understand a jury may not give you everything you're asking for. And that typically gives you that second bite at the apple. Hopefully, if it doesn't settle, it's bringing the parties much closer together on the spectrum of settlement to give you a good shot at avoiding all of the fees that come, with litigation. So that's your 2 bites, right? We prefer that things get settled prior to a lawsuit ever being filed through this RCLA process. But in the event that they don't, it is built in the statute that you get the second bite to hopefully spare you from lengthy and very expensive litigation process. So as we move along here, okay, so we've gone back and forth, it hasn't settled. How can you be sued? And what can you be sued for? So thankfully in RCLA, there is a list of the categories of damages that a homeowner can sue you for. And so they have to do that back and forth, then a lawsuit gets filed. And we're gonna go through here what this list is, right? So your first one here is repair costs. So for a very quick example, I have homeowners where we did the RCLA process and it didn't settle. So then we filed a lawsuit. And my clients then had to go in, hire a different subcontractor, and they went in and they repaired their home. So one of the categories of damages we're asking for is dollar for dollar the amount that my client had to pay a subcontractor to come in and repair their home. So that's category number 1. And here's why this can get tough for you is when my homeowner had to go to the open market and find a contractor, they're paying a consumer premium to get the work done, right? It's way more expensive to my client than it would be to you to either do the work yourself or be able to find someone who's going to give you, other materials and things at cost, right? So now whatever it would have cost you to make the repair, let's say $10,000, my client had to pay out of pocket $15,000, $20,000. And now you've almost doubled your damages here because you didn't settle at the beginning. So that is going to be, one of the categories. So if we move along here, the next category is damage. This is very common in Houston with water damage, right? You did a bad replacement of a pipe and it busted. You did a roof and it's leaking. You didn't seal windows or doors properly and water has come in and it's damaged other aspects of the home. So for example, I had a client who the roof was leaking and it wasn't getting fixed, but he lived in just an exquisite penthouse in downtown. And it had real beautiful, expensive hardwood floors. And it had very expensive mahogany doors and windows. It was very much old, just priceless wood, and not just wood, but artistry and how the wood was carved and put together, and the continual leaking was damaging all of that. And so now not only did we have to fix the roof, but we've got to replace wood, real wood's buckling and all these different things are happening that are now just adding on top of, the damages. So you could be liable for that. The example here is, ruining painting on the wall. So it can flow to a bunch of different directions, whether it's personal property that gets damaged or just actual additional damage to the construction of the home. So if we keep going, relocation, if the homeowner has to move out, which is much more common when, of course, there's been renovation done in the house, water intrusion, things like that, you are responsible for relocation repairs. Now, again, the court kind of puts in a reasonableness factor here, right? They can't move out and be like, well, I'm going to go stay at the Ritz for, 2 weeks. It's got to be a more reasonable relocation repair, but that's another category of damage that you could pay for. And so the next category is stigma value. This one instinctively, a lot of homeowners pick up on this one right away, right? They may not realize they're entitled to get relocation expenses or things like that, but the fact that they now have to disclose on any sort of seller's document that there's been repair work done, especially if it was repair work to the structural portions of the home, For example, water has intruded in through, let's say, walls, it's hit wooden structural beams that have been rotted, that have had to be taken out and replaced, all that sort of stuff that's going to have to be disclosed. It's going to be harder to sell. It may reduce the value of the property. And so they're entitled to that difference, right? Now I don't have a $500,000 home. Now I have a $400,000 home. The problem with this category of damages, which can kind of benefit a contractor, is the fact that this one is very expensive to prove. And sometimes homeowners don't have the funds to be able to prove it. Because what typically happens is a battle of the experts, which always gets expensive. And what you have is your homeowner is going to hire an appraiser or an engineer that has to come in or anything like that to look at how the home was truly affected. Well, of course, they're going to hire the appraiser that gives them the lowest possible value of the house to maximize that difference in the damages. What you're then going to have to do is go hire your own expert to come in and appraise the home and give other testimony, hopefully that says, okay, this didn't actually devalue the property that much. Then you have a battle. And what happens is typically experts charge a price by the hour. And so now you're paying some expert $250 an hour to come out and inspect the home. And then maybe homeowner's attorney wants to take his deposition, or maybe he has to write up a report, or maybe he's reviewing documents. So this one can get really expensive. But again, it is a category that the law provides that a homeowner can recover for a devaluing of their home. And so our next category here is attorney's fees. 100% the first or second question coming out of my client's mouth, right? They want to know that they can get their repair costs back if they've had to repair on their own, and then they want to know that they can get their attorney's fees back. And yes, the law does provide that you as the contractor, if it is found for the homeowner, you will have to pay back the attorney's fees. It's always a negotiating factor. And here's what it does is it makes these cases, the longer that they get drug on, it makes them more difficult to settle, right? Because I have a client that has paid me as the homeowner, let's say $20,000, and they've had to put $30,000 into their home to repair it. So they are out of pocket $50,000. And you come to me and you want to settle it for $25,000. And my homeowner's looking at me like, why would I ever want to do that? Because this contractor refused to engage, or because this contractor refused to do what they should have done from the beginning, I've had to pay out $50,000, and now they want to settle at 25, which is less than half and less than even the amount of repairs I had to make, not even including the attorney's fees that I had to hire to get them to even come to the table. So it makes it difficult, and homeowners will dig in their heels and be like that. It becomes unfair and insulting. But what it does is it becomes hard for you as a contractor, because the way you're looking at it is, well, you paid out $30,000 to do your repairs, and I'm almost paying you back for all of that. And so that's why we'll discuss here in a minute, but that's why it gets so important for you guys in the mediation part or the initial RCLA back and forth to settle quickly, because attorney's fees become a hindrance in settlement. And I have seen that time and time again from the homeowner's perspective, that they get so mad that they had to get an attorney, and you only listen to them once they got an attorney, and they've racked up all these fees that are typically the contractor's fault in some cases. And it just becomes very, very difficult. And so as we move forward here, we're going to see these different options and ways to resolve these cases. One of the last categories is engineering and consulting fees. It's pretty self-explainable, right? So my clients had to come out because of your bad work, and they've had to hire an engineer, or they've had to hire an inspection crew. And those can run $800 to $1,200, and they're entitled to recoup that back. So you can see how, one construction defect can give my client, give a homeowner, give a client the right to start to claim damages in 6 different categories, and how very quickly that can add up. And so the best way for you guys then is to let's try to settle this on the forefront. Okay, so how do we do that? How do we avoid getting into all of these different categories of damages? So if we move forward here, so how do we avoid conflict? And I will tell you, this isn't ever going to solve everything. And the reason is you will absolutely deal with and interact with crazy, irrational, unreasonable homeowners. However, I will tell you that of my recent cases where I have been representing the homeowner, I've had about 5, my homeowners have been reasonable from start to finish. Now, part of my job as their attorney is to talk them down and get them into a more reasonable, realm versus them just hanging out up in the stratosphere. But they're reasonable, right? But you may run into, people who want you to pay for, well, now that you came in, now my dog has anxiety. My dog needs anxiety pills, or now I've been stressed, so I need mental anguish damages, and I need you to pay for my dog's boarding because I had to board them while all the work was being done, or whatever it may be. I have seen examples of it across the board and cases I've read, or other research I've done on this topic. And so that kind of leads into our first advice here. You get to be pretty creative in how you resolve these cases, because not only do you have this back and forth that you have to do, you can use that rigid case law to your advantage, or you can use that time to really communicate with the homeowner. So the first one is trust your gut, right? If you're bidding a job and something feels off, it's better to lose that job than to pay for it in the back end. When you've been around in the industry long enough and you can read people, when you are coming across a homeowner that is just never going to be satisfied, right? Because these cases don't just come up when there is actual bad work done, or actual, busted pipe or leaking faucets or whatever. Someone could just be unhappy, right? They don't like the color you painted is slightly off from the color they picked. They can raise an issue for anything. So if you have that feeling, trust it. I promise it's cheaper to just not do the job. So that's the first easy one, right? The second one is, okay, you're on the job. Over communicate, right? Even if it's something very simple, you're not really in the homeowner's way or underfoot, but you need to over communicate what's going on in the project. Because a lot of the times it's miscommunication, right? Something to keep in mind is this is someone's home, right? It's where they live. It's very personal to them. And it is very much a relationship between a contractor and a homeowner that has a lot to do with things that are outside the legalities of the law, right? I can fight a lot of things on technicalities, on procedures, on what you should or shouldn't have had to do, but this is conflict resolution. And so a lot of times, you can avoid conflicts simply by working with the homeowner every step of the way. So typically people who have had this explained to them and they're not, surprised finding something out 3/4 of the way into the project, things typically go a lot smoother. Warning people of risks is helpful, because even if you think, well, duh, there's always a risk that a pipe is going to burst, or there's always a risk of, certain things. Homeowners don't know that. You know it because you are in the industry. And so this over communication helps them feel comfortable, help them like you, and people are less likely to sue people that they like. For an example, actually, my parents just had, now that they're empty nesters and got all the kids out of the house, they've come in, they've redone the downstairs and the kitchen. and the upstairs bathroom, and they've just redecorated everything. But my parents became legitimate friends with the contractor, and then his wife did some of the interior decorating work. And because of that relationship, you know, that trust that got built up, they really relied on, my parents really relied on the contractor and trusted what they said. They believed them when they had an issue. The client or the contractor responded very quickly, came out, addressed the issue, you know, even if it was something as minor as my parents saying, hey, you've got so-and-so worker coming over and it's just, I know he's not done and he's coming back tomorrow, but he's just left trash all over the bathroom, you know, half-eaten snacks or half-filled Coke cans, things like that. And the contractors responded immediately. They're like, look, I get it. That is unacceptable. You know, they were very sympathetic. They understood that my mom is the type of person that likes that clean house. You know, it's white glove tested and approved. There's no dust anywhere. And that my parents had no issue with the contractor because of this relationship that the contractor was able to build with them. So that is the goal here with this advice of over communicating to the client. Even if you've got someone that is just on staff that is sending some sort of, you know, update email or just calling and saying, hey, we're on week 3. Do you have any questions? Do you have any concerns? We want to talk about it. You know, things like that are really worth it. So if we keep going here, the next step kind of goes hand in hand. It's manage expectations, right? This is the reason conflicts arise in this area of the law. It's the same reason conflicts arrive in normal everyday relationships with the spouse, with the boyfriend, girlfriend, partner, child, you know, whoever it may be. It's because people have different expectations walking into certain situations. And so, you know, let's say you want a mural painted on the wall, and it can be the most perfect work in the world, but you've painted, you know, what we see here, the Mona Lisa, but the homeowner wanted something that looked like Picasso. They're both great, they're just different, right? And so managing that expectations kind of, again, helps you avoid conflicts. That helps with, you know, walking the client through as work's being done, explaining what's going on, just helps people feel comfortable. Having planning meetings, you know, looking at samples, all those typical things, doing what you can to manage those expectations. And one of those biggest pieces is putting it in an easy to read contract. I understand that. And I have a hard time too, right? When I build contracts for my clients, I want every sort of legal piece that could possibly come up that needs to be in there. But the reality is a homeowner is going to be more comfortable with a contract that is easy for an everyday person to read and understand, and then knowing that you're going to follow whatever the scope of work is that is listed there. Don't talk in your shorthand. Don't talk in, you know, industry terms. Really take the time to explain what's going on and what certain terms may mean. So our next slide here kind of, again, goes hand in hand with that. Managing expectations is managing your schedule, right? I don't know if I've ever seen, you know, projects ending on time or on schedule for whatever reason it may be. We are in a time in a society where things are being difficult that are outside of your control as a contractor. You know, whether it's a labor shortage, whether it's a supply shortage, whether it's these increasing prices of lumber, whatever it may be, you need to be honest about your schedule. Guess what it's going to be and add a couple weeks, you know, add a month, whatever you need to do so that when you come in either under budget or under the time frame, you're now a hero, right? They now love you. And what does it do? It helps your business because you're now being recommended to other people because you've done, you know, things like this. And so you're kind of like, okay, well, what are my practicalities of what I need to avoid to be sued? Like what do they have to sign and how should I phrase my emails? But the reality is, especially in this area of laws, it has to do with building good relationships, right? And so that's why all of these recommendations here have to do with ways for you to keep someone happy. And this is definitely one of them. People get more frustrated when things aren't done on time because they have plans, right? They want this done before the holidays. They want it done before someone's birthday or visitors come in town, or it's just a headache to have someone in your home for any length of time doing work. They want to get back to normalcy. So that's why this one is so important. So as we move along, this goes back to like the price increase and labor shortages. Have a plan for how contingencies are going to be addressed. And again, you can put that into a simple, easy to read contract. They have it in writing. You also talk to them as projects are going, just be really frank and honest about the issues you're facing as a contractor. You don't need to sugarcoat it to be the most attractive on the front end, because when you are gassing up this homeowner and then things go wrong, you're getting a lawsuit. You're getting problems and issues, and people appreciate all of that honesty. So making sure you're doing that up front. And I'm not saying that, y'all as contractors are intending to do any of these things, right? You just maybe are ready to get started, ready to complete the project, ready to get that check in hand, to move along to the next one. But this is this extra level of relationship and humanity that you need to be very conscious of going in, so that way there's not fights later. And honestly, having a plan for contingencies that the other side agrees to helps you avoid needing me in the long run or needing to call us. Doesn't take your risks or lawsuits down to zero, but it may take them down from 10 unhappy customers a month to 2, right? And that's a huge decrease. And so that's why these things are so important. We do contract review, we do contract drafting here, we can create templates, all these sorts of things. Create yourself a checklist of what to go over with your client to make sure every piece of this is hit to avoid these conflicts. And again, the other thing to be clear is what's your payment schedule? When and how are you expecting payment? Don't just go in all willy-nilly of like, oh, I've been working for a week, maybe I should ask for a draw, or maybe I should ask for a check, and then you say I need 50%, the homeowner's like, I'm only paying you 20%. Don't get into those conflicts. Don't get into those arguments, because it's already clear in your contract, or you're sending invoices and everything's being explained as you go. You don't have those issues. Money is a tough subject to talk about. You may know the value of the work, but the homeowner may not. And so instead, if you have a payment schedule, if you have that trust built up, people don't have a problem cutting checks to those that they trust and they feel comfortable with. And again, that keeps decreasing your conflict as you're moving forward. So as we continue here, here's our recommendations. Okay, you did everything you tried to do, and now a conflict still occurred. So how are we going to resolve it? So your first step here is listening. And I know this feels like things that we were taught in 3rd, 4th, 5th grade, but we're all guilty of it. We're all bad at it. You're formulating your response while they're talking to you, and you're not listening. I will be honest, one of the things when I started practicing is not realizing the amount of times where I've got a law degree, but I'm operating as a therapist sometimes to clients, whether it's business clients or homeowners. A lot of my job is just to be sympathetic. And that's going to be part of your job too, to prevent these conflicts. Just be sympathetic. Man, I get how frustrating this is, and I'm really sorry that this has happened. And I'm going to reassure you that we're going to get this taken care of. Whatever it may be, can be very helpful. Second advice here is to take notes, right? Write everything down. And that way, twofold, they have confidence in you that you are listening, and 2, you're not going to forget what they were listing out to you. And then on top of that is this next slide here is when they're done, repeat back what their issues are. Again, this is effectively getting you down to the communication, right? What matters to them? And it goes across all areas. I get clients that come in and I'm like, look, we got a lot of options. What are your goals? What is it that you really want? Because sometimes what you really want may be just a piece of what's available to you. And that makes cases easier to settle. When you're only asking for a bite instead of the whole pie, it's a lot easier to share your pie with someone who just wants a bite, right? And so that's why this is so, so important. And so then what you need to do for our next step here is take your time to investigate. And what does a good investigation or good inspection, like we talked about at the beginning, do? It allows you to put together a settlement that is gonna be reasonable. And your benefit here is if you put together a very reasonable offer and even supplement it and it still gets rejected, you have the ability to cut off the other side's attorney's fees. And if they don't let you come in and inspect when you requested it, you get to cut off their attorney's fees and further limit their damages. So by you taking these right steps and being as reasonable as possible, you are in effect protecting yourself. Doesn't mean you still won't have to pay, maybe a repair cost, maybe you did do something wrong, but you don't have this prohibitive issue of all of these attorney's fees. Now, again, the problem with that is reasonableness is tricky. And sometimes it is not something that's determined until you're in front of a jury. But what you can do is you can say, but look, I did a good investigation. And so for a real quick last example here on someone who failed to investigate is, I have a client and they had some issues with their stucco. They were looking at their home, they noticed there's some cracks. So they call someone out to come inspect. That inspector comes, they do temperature readings, they do moisture readings, they probe different areas of the house, they see that substrate has been damaged, they know the likelihood that a structural beam has been damaged, they can see where maybe water intrusion was happening, and they did a full-blown investigation. We had like a 25 page report that is detailing per piece of the house, inside and outside, on a grid, arrows that are pointing to where cracks are, or where substrate was soft and where substrate was hard and unaffected, and why they thought water flowed a certain way. Super detailed. And a recommendation of everything that needed to be done and the consequences if they weren't going to be done. That gets sent off to the home builder. The home builder comes and their investigation was to take an iPhone and take pictures of cracks. Or if the homeowner said, well, the window leaks when it rains, he took a picture of it. I don't know how that leads to any sort of thorough investigation, because they didn't do anything to be able to contradict what my client's inspection report said. They weren't able to go in now because now the home has been repaired. So they missed their opportunity to see if my client's claims were legitimate, to really see if the substrate was in fact damaged. And so that's why this investigation becomes so important, because not only does it allow you to give a full, thorough, reasonable offer, but it allows you to protect yourself, right? If you need to go hire someone else, a different company to go do an inspection, that's helpful too, right? Because they don't have any loyalty to you. You may look at it and be like, I did good work, it's fine, I don't even want to inspect. And that can create a problem. And what does it do for the homeowner? If we go back to this relationship aspect, is they think you don't care, right? And so that is a great way for you to take the time, make it right on the outset, even if your work was fine, even if it's insulting what they're saying about your work. I promise it's cheaper. And I promise you get better recommendations when you react to a homeowner that way, because you, in their eyes, you owned up and you fixed it and you made it right. You're going to get more business in the long run. And so I have a lot of cases where if there were just better communication during that initial RCLA phrase, that back and forth, the case would have been settled. But instead, the builder decided to be rigid and just be like, my offer was reasonable. We're not going to talk about any sort of additional negotiations. Now we're in a lawsuit. And yeah, you're right. You sent me an offer and you didn't have to do anything else. You didn't have to. And it very well may be a good strategy decision to not further engage. But I would say a good majority of the time, it makes more sense to get it resolved quicker and faster. So lastly here in conclusion, like I've said several times, not everyone's going to be happy, right? You can't make everyone happy. And what we want to do is give you twofold, give you the tools to make most of them happy and get it mostly resolved. And then number two, if you follow a lot of those steps, you have the paperwork, you have your efforts to help document against these homeowners that may be unreasonable or kind of off the charts with what they're asking you to do. So remember, act reasonably. It's a hard word, it's a squishy word. I can't define what that is. But if you think, okay, well, this is reasonable, maybe what you do is just go a little step further, right? Just in case. And so look, I know it's complicated work. I know it is tricky, and every situation is going to be different because every time personalities are different. But we do a lot of this work here at the Cromings Law Firm. You know, we have a lot of ways to protect you. You know, if you've dealt with this before, you know we try to be proactive and to prevent different things from occurring before they even occur. And then we're always here on the back end once these conflicts do arise. So that is it, you guys. Thank you again for joining us on this lunch hour. You know, it's 12:50 now. I'll stick around for however many questions that we have. But you can always give us a call, reach out to me personally, whatever you need to do. We'll get you to the right person to answer any questions you may think of in the coming days if they're not popping up right now.
Awesome, awesome. As Kelly said, you're more than welcome to ask questions at this time. You can send them in the chat and I can ask questions, or you're more than welcome to unmute yourself and ask them to Kelly yourself.
I have a question. Kelly, thank you so much for putting together this presentation. It was super informative. Definitely learned a lot. Is there a statute of limitations for which a homeowner can file a claim for construction defect?
That's a really good question. The answer is kind of yes and no, weirdly, to that question. So if you're a home builder, then after 10 years after the home is built, no claims can ever be made for any sort of construction defect, whether they're discovered or not discovered. So the law has already just said, you know, for that realm, after 10 years, we just assume that there's wear and tear and things are happening. Now for construction defects, as far as like maybe repairs or remodeling of the home, that gets a little trickier because the time doesn't necessarily run when you did the work. The time may run from when the homeowner knew or should have known of the defect. And so that's where it can get a little tricky. And RCLA itself, back and forth process we just talked about, doesn't have, is not its own cause of action. So when you get a lawsuit handed to you, it doesn't say violation of residential construction act. It says negligence, it's breach of warranty. For those 10 years, years from date that they've discovered the defect or should have discovered the defect. And that's what we call latent, the should have discovered, those are latent defects. Those are ones that are apparent, you know, you installed cabinets that didn't shut properly, right? The first time you open that cabinet, obviously you're gonna know, versus something maybe in your plumbing is wrong and it's leaking in the interior of the house and you're never gonna notice that until all of a sudden, you know, you're seeing water stains or you're seeing drippage or your ceiling busts in or whatever it may be. That starts that 2-year limitation. DTPA, which is the violation of the Deceptive Trade Practices Act, you see that one's very common. There is a way to get those types of claims or those extra damages associated with those claims waived. That's a whole nother legal discussion, but that one is 2 years as well. And then any sort of breach of contract claim is 4 years. breach of contract typically is going to start running most of the time once you finish the work, right? Because what that breach of contract is, hey, you didn't do what I asked you to do. You never installed cabinets, or you painted it the wrong color, or, you know, you walked the job, whatever it may be. The negligence, you know, and breach of warranty. Now, to be clear on the warranty, you can give warranty for your work. That's called express warranty. But no matter what, you always are carrying with you an implied warranty of good and workmanlike work or craftsmanship. And so basically that fits hand in hand with negligence of you just did bad work. And you warrant by showing up and doing work that you're not going to intentionally be doing bad work, right? That's pretty common sense. So that's typically what you see. So it's kind of a case by case basis. You know, what type of trade are you in? Really, it's tricky for people who do work that is more on the interior parts of a home, whether by interior I mean inside walls, whether it's interior, exterior walls, or, you know, window installation. We hit a dry spell and it never rains, and then all of a sudden a hurricane comes, and now we're seeing that there's water intrusion. And so I'm sorry I can't give you like a real strong answer there. But, you know, typically it depends on what the defect is, but on the short end, it's 2 years, and very rarely is it going to be up to that 4-year time frame. And so that's why when you get these things settled, you know, having these issues, getting those releases with them that the client signs on the homeowner signs on a settlement, can release any other claims that they may find or may not find, as long as they're not something you're intentionally concealing from them. And that's another great aspect of why you should settle these, because you can get a much broader release than the work that you did, right? You can get them to waive pretty much every additional claim against you. And that's a very helpful way to limit your future damages as well.
Thank you.
Yes, ma'am.
That's a great question. Does anybody else have any questions for Kelly? Just some thank yous in the chat. Glad you guys enjoyed the presentation. Kelly, I've got one for you.
Okay.
So say you are, you've finished a project and a homeowner notices something a little bit later on. Are you protected from any RCLA claims once your warranties expire?
That's a really great question. And I'll say that for my cases where I have been representing homeowners, that is the biggest defense that's being put up against us right now. They're saying, hey, look, you're making a claim of stucco defects, but under my warranty, I told you you had 2 years, my warranty covered 2 years worth of stucco defects, and we're 6 years down the line. You can't bring this claim. But warranty, by me getting a warranty or me signing a warranty or whatever, doesn't mean that me as a homeowner has waived my right to any of these other claims. You're right. Maybe under the warranty, you don't have to come fix it. But if a court finds that it was work that was done that was so defective for other reasons, it can still be a valid claim. So you're right. If I do notice cracks in my stucco and I'm outside that 2 years, you know, you come in and you repair it. And after that, you know, it's up to me. Maybe I need to get someone out there to professionally caulk it better or to seal it. That's normal maintenance. But what the concern is when these damages are much more than just your warranty stepping in to assist with normal wear and tear or potential like issues with construction that are unpredictable and just happen sometimes versus actual bad work that was done. So the argument against it in the stucco example is the fact that they didn't let the stucco cure long enough before they painted it. And so by the way they constructed the home, they've created all of these stucco issues. Whereas if they had done it properly, yeah, sure, the warranty would have come into play. I would have been responsible for everything else. But they didn't do flashings correctly at the top, which had nothing to do with the stucco. It allowed water to then come in, get behind the stucco, hit the wall, and then just like a ripple effect, right? Just went all the way through the home and it just permeated the home. And so, okay, that doesn't even apply to your 2-year stucco warranty now because it's not an actual issue with the stucco. And so, yeah, the warranty is helpful. I think you should always have one for your work. I think it helps, make you look reasonable. It helps make you look like you have confidence in your work and it's something you should have, but it is not an absolute protection to these types of claims because they can be very nuanced and very tailored with how the law looks at them. That can lead you to liability later.
I see. That's really helpful. Thank you. Jorge in the chat says, oh, I'm
I
sorry.
have a question. I apologize. I have a question. If we carry a product that has a warranty of its own, and we sell it, we install it, and yet it still fails, and the warranty again is through the product itself, but they do not uphold their warranty if the customer processes a claim, let's say, directly with the manufacturer. And do we have any obligation as a company to the customer?
Yeah, that's a great question. The short answer is no, depending on, what was your contract with the homeowner. So if your contract is, I'm just going to take a silly example, right? My contract with you was to just purely install a faucet in your bathroom. I get it from whoever the manufacturer is, because I get it at cost. I come in, I just install the product. My installation is flawless. Well, that's it. That was the only thing that I said I was going to do for you. As long as you don't have anything in your contract that is warranting that you're getting them a perfect product, you should be fine. Now, granted, you need to inspect the products, make sure they're not faulty, make sure the supplies you are using are as good as you can to your knowledge, but the warranty then would come from the actual manufacturer themselves. And, typically the way these work is you get that warranty for the project, it gets passed along to the homeowner then can act on it as they see fit. But if the work that you did remains above reproach, then you don't really have an obligation. That is the legal answer. Now, a good practical answer is doing what you can to make sure that the homeowner is happy, right? But do you have to? No, of course not. I would still want you to maybe do a little more than just like, not my problem kind of response. But
Right.
it is not something that is really going to be something that you have to legally do. Again, as I advise all my clients, sometimes I know that legally you don't have to do something, but it's going to be more expensive if you go that route. And some clients want to be on that principal route, and I get it, and I will fight for those legalities all day long. But I think as long as you're doing what you can do to get good products, to get effective products, non-damaged projects, all those things, whether it's just a pure document that you have when products come in to show that they've all been inspected by not just the manufacturer, but you guys as well. I think that really helps absolve you of any sort of liability as long as the work that you promised to do is done correctly.
Okay, thank you.
You're welcome.
And then to answer Jorge's question in the chat, can we get a copy of the presentation? Yes. We will be sending a copy of the presentation and the handout once again to you all, in addition to Kelly's contact information in our follow-up email. So keep your eyes peeled for that. And if we don't have any more questions, give it one more second, see if anyone's got anything else to ask Kelly. Alrighty. Well, thank you all for joining us this morning. Hope you enjoyed the presentation. And like I said, we'll be following up very shortly with the presentation, a copy of it, as well as the handout and Kelly's contact information if you do have any questions that come to you later on. So thank you, everyone.
Thank you all. Have a good afternoon.